La Cour. Please be seated. I declare open the hearing for the delivery of a judgment of the European Court of Human Rights in the case of Kavala versus Turkey No. 2, pursuant to Article 44 of the Convention and Rule 77, Paragraph 2 of the Rules of Court. The agent of the government and the representatives of the applicant have been duly informed of the date and time of the hearing. The government are represented by Mr. Selayir, legal counsel of the permanent representation of Turkey to the Council of Europe. The applicant is represented by Professor Celi. The Council of Europe Commissioner for Human Rights is represented by Mr. Mathieu Birker, advisor to the Commissioner. I welcome the representatives in the name of the Court. The judgment delivered today concerns an application that was lodged by Mr. Kavala on the 18th of January 2024 under Article 34 of the Convention. The application was allocated to the second section of the Court, pursuant to Rule 52, Paragraph 1 of the Rules of Court. On the 21st of March 2024, the President of the section decided to apply Rule 41 and grant the applicant's request for priority treatment. The government were given notice of the application on the same date. On the 16th of December 2025, the Chamber decided to relinquish jurisdiction in favor of the Grand Chamber. The Council of Europe Commissioner for Human Rights exercised his right to intervene in the proceedings before the Grand Chamber by submitting written observations and participating in the hearing. Furthermore, 9 non-governmental organizations and 1 individual were granted leave to make written submissions in the proceedings before the Chamber in accordance with Rule 44, Paragraph 3a of the Rules of Court. This authorization was maintained for the purposes of the proceedings before the Grand Chamber. On the 3rd of February 2026, I authorized a further 7 organizations to intervene as third parties in the proceedings. The Grand Chamber held a hearing on the 25th of March 2026. It adopted its judgment on the 2nd of July 2026. I shall now provide a brief explanation of the facts of the case and of the Court's assessment of each complaint. This case concerns the applicant's detention and subsequent conviction, resulting in a sentence of aggravated life imprisonment. The applicant claims that these measures were taken against him because of his activities and his public stance as a human rights defender. The Court had already examined the applicant's situation in its judgment of the 10th of December 2019. In that judgment, the Court found violations of Article 5 and 18 of the Convention, ruling that the applicant should be released immediately. The present case relates to events that occurred afterwards. On the 18th February 2020, the Istanbul 30th Assize Court acquitted the applicant of attempting to overthrow the government under Article 312 of the Criminal Code in connection with the Gezi Park events. The Court also ordered his release pending the final outcome of the related proceedings. However, he was not released. On the same day, he was arrested again in connection with an investigation into acts punishable under Article 309 of the Criminal Code relating to the attempted coup d'etat of 15 July 2016. The following day, he was placed in pretrial detention on this charge. It is also important to note that, at the same time, the Council of Judges and Prosecutors initiated a preliminary investigation and subsequently opened disciplinary proceedings against the 3 judges of the Istanbul Assize Court who had acquitted the applicant the previous day. From the 9th of March 2020 onwards, the applicant was also kept in pretrial detention on an additional charge of military or political espionage under Article 328 of the Criminal Code. On the 28th of September 2020, the Istanbul Public Prosecutor's Office filed an indictment charging the applicant with attempting to overthrow the constitutional order and with military or political espionage under Article 309 and 328 of the Criminal Code. On the 22nd January 2021, the acquittal judgment relating to the Gezi Parks events was overturned. The applicant was then convicted of charges relating to those events and, on 25th of April 2022, sentenced to aggravated life imprisonment. However, he was acquitted of the espionage charge at the same time. This conviction was subsequently upheld on appeal and confirmed by the Court of Cassation in September 2023. The first issue raised in today's judgment is whether the applicant was required to await the outcome of the 2 individual applications pending before the Constitutional Court at the time he submitted his application to the European Court. The judgment dismisses the government's objection on 3 main considerations taken together. Firstly, the judgment considers the exceptional circumstances of the case and the applicant's personal situation since his arrest on 18th of October 2017. The applicant has been deprived of his liberty without interruption, totaling more than 8.5 years. Throughout this period, he has consistently and diligently used all available domestic remedies. However, none of these remedies have led to his release, nor have they provided adequate acknowledgement of the violations identified or appropriate redress. Secondly, the judgment notes that the applicant's case is characterized by the domestic authorities' persistent failure to execute previous court judgments relating to the Gezi Park events and the charges brought against Mr. Kavala in this respect. Thirdly, the judgment finds that the proceedings before the Constitutional Court were excessively lengthy, despite the fact that individual liberty was at stake. The judgment finds that these delays are manifestly excessive in the particular circumstances of the case. Taking these 3 considerations together into account, the judgment concludes that the applicant cannot be criticized for not awaiting the outcome of his individual applications to the Constitutional Court, given that the effectiveness of this remedy has been seriously compromised. However, the judgment stresses that this conclusion is strictly limited to the specific circumstances of this case and does not call into question the general effectiveness of such remedies. Lastly, the judgment expresses concern about the applicant's argument that the domestic courts refused to give effect to the Constitutional Court's judgments in 2 cases concerning his co-defendants. In this regard, the judgment reiterates that deliberately failing to implement the Constitutional Court's judgment can undermine the rule of law and the effectiveness of individual applications to the Court for human rights violations. The second question examined in the judgment is whether the measures complained of amount to interference with the applicant's exercise of his rights to freedom of expression and peaceful assembly under Article 10 and 11 of the Convention. The judgment states that the acts underlying the charges and the applicant's conviction mainly consist of participating in public debates, supporting civil society initiatives, disseminating information, and engaging in advocacy activities connected with the Gezi Park events. These activities are covered by Article 10 and 11 of the Convention. The judgment also emphasizes the essential role of human rights defenders and NGOs as public watchdogs in a democratic society. It therefore concludes that, insofar as they are linked to the applicant's human rights activities and involvement in the Gezi Park events, the criminal charges and conviction constitute an interference with his rights under Articles 10 and 11. The judgment further finds that the interference was not prescribed by law. It considers that Article 312 of the Criminal Code has been interpreted by the domestic courts in an unforeseeably broad manner. Although that provision concerns the offense of attempting to overthrow the government by force and violence, the applicant was not found to have personally committed, incited, or supported any violent act. Rather, his criminal liability is based on his alleged influence within the Gezi Park movement and on activities such as civil society work, contacts with international actors, advocacy, documentation of human rights violations, and support for peaceful demonstrations. The judgment notes that these activities are an ordinary exercise of the right to freedom of expression and peaceful assembly. By equating them with the material elements of an exceptionally serious criminal offense and attributing violence committed by third parties to the applicant without any direct or intentional link, the domestic courts failed to provide adequate protection against arbitrariness. Moreover, such an interpretation is liable to have a particularly serious chilling effect on the exercise of the freedoms guaranteed by Article 10 and 11 of the Convention. The prospect of prosecution for an offense punishable by aggravated life imprisonment would likely discourage not only human rights defenders or civil society actors, but also ordinary citizens from participating in, organizing, or providing logistical, financial, or intellectual support for peaceful demonstrations. When applied to nationwide protest movements, such an interpretation carries the risk of ex post facto reclassification under criminal law when sporadic violence occurs on the margins of gatherings. The judgment, therefore, concludes that the interference in question cannot be regarded as prescribed by law within the meaning of Article 10 and 11 of the Convention. Accordingly, it finds a violation of those provisions. The third question examined in the judgment concerns the fairness of the criminal proceedings under Article 6, paragraph 1 of the Convention. The judgment observes that the applicant's case was examined by several different judicial formations, following repeated decisions to join, sever, and reassign the proceedings. Moreover, after the applicant's acquittal by the Istanbul 13th Assize Court, disciplinary proceedings were brought against the judges who had acquitted him. The judgment considers that these circumstances, taken together with the broader political and judicial context, require particularly careful scrutiny. The judgment also highlights significant shortcomings in the reasoning of domestic courts. While the offense under Article 312 of the Criminal Code involves the use of force and violence, the courts failed to establish a concrete causal link between the applicant's actions and the violent incidents that occurred during the Gezi Park protests. Instead, the applicant's conviction was largely based on contextual and insufficiently individualized inferences with no proper assessment of the material and intentional elements of the offense. The interpretation of the criminal law was arbitrary and unforeseeable to the applicant's detriment, resulting in a manifestly unreasonable outcome. The refusal to hear key defense witnesses, combined with the lack of effective review by the higher courts, further undermined the fairness of the proceedings. Regarding the independence and impartiality of the domestic court that convicted Mr. Kavala in relation to the Gezi Park events and sentenced him to aggravated life imprisonment, the judgment highlights that several factors could raise legitimate doubts in the eyes of an objective observer. These include the disciplinary investigation opened against the judges who had previously acquitted the applicant in light of these factors, and the structural concerns regarding judicial independence in Turkey. The judgment concludes that these shortcomings were not merely procedural flaws, but fundamentally impaired the applicant's rights to a fair trial. The judgment finds that there has been a violation of Article 6, paragraph 1 of the Convention. The fourth question examined in the judgment concerns Article 5, paragraph 1 of the Convention and the lawfulness of the applicant's deprivation of liberty since the Court's 2019 judgment. The judgment distinguishes between two periods. The first period is between the previous Court's delivery of its judgment of the 10th of December 2019 and the applicant's subsequent conviction on 25th of April 2022. In this respect, the Court rejects the government's objection that the complaint was lodged outside the time limit. Regarding the merits of this complaint, the judgment states that the applicant remained in pre-trial detention despite the Court's earlier finding that the suspicions against him were insufficient and were largely based on acts protected by the Convention. The domestic courts extended its detention on the basis of the same evidence, reclassified under different criminal offences without identifying any new facts, strong suspicion, or relevant grounds capable of justifying his continued detention. The judgment therefore concludes that the authorities act in bad faith, seeking to circumvent both domestic law and the Convention in order to keep Mr. Kavala in detention. Since the 25th of April 2022, the applicant's detention has been based on his conviction and the imposed sentence of aggravated life imprisonment. However, the judgment finds that this conviction resulted from proceedings constituting a flagrant denial of justice, characterized by significant deficiencies affecting fairness, independence, and impartiality as previously determined under Article 6 of the Convention. Furthermore, the conviction was based on an enforceable interpretation of criminal law and activities that are protected by Article 10 and 11. Accordingly, the judgment concludes that the applicant's detention, both before and since his conviction, has not been lawful within the meaning of Article 5, paragraph 1, and that his deprivation of liberty since the 10th of December 2019 amounts to a violation of the Convention. The fifth question examined in the judgment concerns whether the measures taken against the applicant pursued an ulterior purpose within the meaning of Article 18 of the Convention. The judgment states that the case should not be considered in isolation, but rather in the broader context of the detention and prosecution of human rights defenders, journalists, and political opponents on the basis of serious and often exaggerated criminal charges. It notes that in its 2019 ruling, the Court had already found that the applicant's detention was not based on reasonable suspicion, but rather pursued the ulterior purpose of silencing him and discouraging other civil society actors. Today's judgment concludes that subsequent proceedings did not dispel these concerns. No new concrete or convincing evidence was presented, and the applicant's conviction was largely based on his civic, associative, and public interest activities rather than on any specific acts of violence. The judgment also takes into account the serious shortcomings affecting the fairness, independence, and impartiality of the proceedings, as well as public statements by high-ranking officials which have contributed to a climate of political and media pressure. It considers that the repeated legal reclassifications, successive detention orders, and continued deprivation of liberty have had the effect of neutralizing judicial decisions in the applicant's favor and prolonging his detention. In particular, the judgment recognized the exceptional gravity and emblematic nature of the applicant's situation. This is due to the duration and intensity of the interference with his fundamental rights, as well as the implications which extend far beyond his individual situation. Authorities pursued an ulterior purpose to stifle pluralism and restrict freedom of political debate. These principles lie at the very core of democratic values and European public order. The judgment also finds that the criminal proceedings, the applicant's continued detention, and his conviction were preeminently motivated by the ulterior purpose of punishing him for his role in the Gezi Park events, for his opinions as a human rights defender, and of silencing him. Accordingly, the judgment finds a violation of Article 18 taken in conjunction with Articles 5, paragraph 1, 6, paragraph 1, and 10 and 11 of the Convention. The sixth issue considered in the judgment relates to Article 3 of the Convention, and more specifically, the sentencing of the applicant to aggravated life imprisonment. The judgment refers to the Court's established case law, which states that an irreversible life sentence is incompatible with Article 3 if there is no genuine prospect of release and no mechanism to review the sentence based on the prisoner's personal development or continued dangerousness. The judgment therefore concludes that the aggravated life sentence imposed on the applicant amounts to a violation of Article 3 of the Convention. The judgment holds that, given the findings above and the close connection between the complaints raised, there is no need to examine the admissibility or merits of the applicant's other complaints. An important part of the judgment concerns Article 41 and 46 of the Convention. Under Article 41, the judgment awards the applicant just satisfaction in respect of non-pecuniary damage as well as costs and expenses. The section of Article 46 is particularly significant as it indicates both individual and general measures. Firstly, the judgment states that, in accordance with Article 95 of the Constitution, Article 46 of the Convention is of constitutional value in Turkey. Therefore, the obligation to execute the Court's judgments is not only a matter of international law, but also a binding requirement of the rule of law as set out in Article 2 of the Constitution. Secondly, with regard to individual measures, the judgment finds that if the applicant's detention were to continue after the present judgment, this would constitute an extension of the violations already established, particularly the violation of Article 5, paragraph 1. Given the gravity of the established violations, the judgment states that the respondent state must ensure the applicant's release as soon as possible. The judgment further emphasizes that, where possible, the applicant should be placed in the position he would have been in had the Convention not been violated. In this regard, it states that, under the Convention law, the applicant's criminal conviction should be regarded as null and void. It also noted that the reopening of proceedings following a final judgment finding a violation of the Convention is provided by domestic law, and that all appropriate measures to eliminate the consequences of the violations found must be adopted by the respondent state. Thirdly, regarding general measures, the judgment concludes that the case highlights a systemic issue and identifies structural deficiencies impacting the independence and impartiality of the judiciary, particularly in politically sensitive cases. The judgment therefore stresses the need to strengthen institutional safeguards against undue pressure on judges. It also highlights the importance of preventing the misuse of criminal proceedings for purposes unrelated to the proper administration of justice, particularly through the excessive use of pretrial detention, broad criminal classifications, and successive prosecutions. Lastly, the judgment emphasizes the importance of full and prompt compliance with the judgments of both the Court and the Constitutional Court. In light of its finding under Article 3, it also notes the existence of a further systemic problem concerning life sentences without the possibility of release in Turkey. The judgment indicates that this issue requires appropriate legislative measures. Having explained the Court's reasoning, I will now read the operative provisions of the judgment. The Court, point 1, dismisses by a majority the government's preliminary objection concerning non-exhaustion of the individual application before the Constitutional Court. Point 2, declares by a majority the complaints concerning Article 3, absence of a mechanism to review the sentence of aggravated life imprisonment, 5, paragraph 1, 6, paragraph 1 and 3d, independence and impartiality of the court, fairness of the proceedings, restrictions of the rights of the defense, 10, 11, and 18 taken in conjunction with Article 5, 1, 6, 1, 10, and 11 admissible. Point 3, declares by a majority the complaint concerning the length of proceedings, Article 6, paragraph 1, inadmissible. Point 4, holds by 15 votes to 2 that there has been a violation of Article 10 and 11 of the Convention. Point 5, holds by 15 votes to 2 that there has been a violation of Article 6, paragraph 1 of the Convention in respect of the complaints concerning the independence and impartiality of the court, the fairness of the proceedings, and the restrictions on the rights of the defense. Point 6, holds by 15 votes to 2 that has been a violation of Article 5, paragraph 1 of the Convention. Point 7, holds by 15 votes to 2 that has been a violation of Article 18 of the Convention, taken in conjunction with Article 5, paragraph 1, 6, paragraph 1, 10, and 11 of the Convention. Point 8, holds by 15 votes to 2 that has been a violation of Article 3 of the Convention in respect of the complaint concerning the absence of a mechanism to review the sentence of aggravated life imprisonment. Point 9, holds unanimously that there is no need to examine the admissibility and merits of the complaints under Article 3, the applicant's continued detention, 5, paragraph 4, 6, paragraph 2, and Article 7 taken separately or in conjunction with Article 18 of the Convention. I will not read out the remaining operative provisions, namely points 10 and 11, which relate to judge satisfaction and the individual and general measures. It is sufficient to note that the judgment awards the applicant compensation for the non-pecuniary damage suffered as a result of the violations identified in the case, and sets out the aforementioned individual and general measures. Following this hearing, the full text of the judgment will be published on the Court's website and made available in the EUDOC database in both English and French. A legal summary and a press release prepared by the registry will also be available. I now declare the public hearing closed.